Also a jet protectee. This is your argument. Ms. Singhvi will submit it. Singhvi would submit it. So it is a jet protectee. Therefore, it was the duty of the Director General of Police to accompany her when she entered the premises of Mr. Pratik Jain. Sri Shyam Diwan, learned senior counsel, appearing for so and so, or as one number 4 and 5, would argue that when the that it is factually correct that some untoward incident happened when the High Court proceeded to hear the matter on 9th January, but thereafter, on 14th January, the matter proceeded peacefully but has been adjourned at the request of the ED. Therefore, this court should wait for the outcome of the proceedings pending before the High Court. Having heard learned counsel for both the parties, we are of the prima facie view that the present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and its interference by state agencies. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that the offenders are not allowed to be protected protected under the shield of law enforcing agencies of a particular state. According to us, larger questions are involved, has been raised and are involved in the present matter. If allowed to remain undecided, would further worsen the situation, and there will be a situation of lawlessness prevailing in one or the other state, considering that different outfits are governing at different places. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, the question arises as to whether in the shield of taking shield of its party activity, the agencies can be obstructed in carrying out their investigating power in a bona fide manner. Issue notice to the respondents. Let counter affidavit be filed within 3 days. Can you file it within 3 days?
Not possible.
Within a week.
Give some time, at least 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we'll preserve all the material. If it takes longer time, because the digital
Not
evidence.
preserving, Maharaj. Your losses make
Yes.
no issue on that.
Yes,
Uh,
in 2 weeks.
2 weeks.
Post the matter on. Is 50. Post the matter on 3rd February.
Prayer A and E.
Full stop. Full stop. In the meanwhile, it is directed that the respondents shall preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8/1/26 as described in the writ petition, and the CCTV cameras and storage devices containing the footage of nearby areas. Now, what it is to this? No, investigation. And the CCTV 8/1/26 full stop. It is also directed that the further proceedings and the investigation relating to FIR number 3 of 26, 4 of 26 and 5 of 26 registered at electronic.
There is one more, 7 also, my lord. I have placed on record.
It is there in the main petition, but not here.
In the additional document, it was filed
7 of
subsequent.
26 registered at electronic PS, Vidhan Nagar.
No, there are 2 from Shakespeare Sarni.
Just name the police station properly.
No, it's in E. E has, my lord, the police station, page 126 E. 2 are, my lord, from Shakespeare Sarni, and 2 are from electronic PS Vidhan Nagar. The index, my lord, in the present.
In this IA.
Yes,
Direct.
it's a document compilation.
Is also direct that FIR number 3 of 26 and FIR number 4 of 26 registered at police station Shakespeare Sarani, and FIR number 5 of 26 and 7 of 26 registered at Electronics Complex PS shall remain state till the next date of hearing.
Or any other FIR pertaining to this?
So we may not be aware of.
This is
We
not
do
like
not
a
know.
blanket order.
There should be clarity in our order.
Yes,
You
sir.
can't say that any other this
No, I understand.
is not proper.
Great.
Whereas I have one request, for you, just Lordship considering. Whereas normally a Lordship does not stay investigation. No coercive steps will be taken is an alternative.
No. You see, in
Investigation.
view of section 67, if they were armed with a letter of authorization, they were acting in good faith.
So I'm only saying, well, investigation without any coercive steps.
Mr. Singhvi, you
No.
understand the delicacy of the matter.
But equally, well,
If you
delicacies on
proceed,
both sides.
if you proceed with the investigation in any manner,
But
then
without
it will be
any
difficult,
coercive
but
steps.
then we will.
Without any coercive steps.
No, my lord,
In any manner.
that may not.
Secondly, Willis, if your Lordship is granting a stay on investigation, then let us have more time to reply, Willis, because then there will be a complete stay on investigation. Let us take out all.
No. 15
There has
days
to
is
be
enough.
more,
What more you want?
Willis, maybe 3
In
weeks
fact,
or
this
4
order could have been passed after 10 minutes of hearing. We indicated to you that we are inclined to issue notice. But since both the parties have raised that much of argument, it is necessary for us to record also.
Yes,
Because
be a little
nowadays it is aired, everything.
now
And
that
then
it is,
everybody will say that court has
Now
not
that it is
recorded anything,
stayed,
so much was argued.
now that Lordship has stated, little more time can be given. That's
Yes, next case.
My lord, the IA for addition of party, for Chief Secretary and others are being joined. And my lord, prayer for
Chief Secretary.
suspension. No, suspension power is with the chief
No,
secretary.
that's suspension.
That's my prayer. That's my prayer.
We file a counter.
That's my prayer, my lord.
Let's
Strongly opposing this kind of running of.
Notice may be issued.
let counter to IA number so and so
Yes,
may also be filed.
yes, yes.
It's not even listed, my lords. It's not even listed.
No, it's given, my lord. Copy is
Because
given.
it's
Therefore,
got-
I have tendered
These
it.
are the strange
You
procedure.
kindly list it tomorrow, my lord.
Whatever
Let
it
them
is,
file a
it's
reply.
not
I
even
may not
listed.
get the relief today.
That's not.
You only file counter. We are not saying anything. No passing
Yes.
no orders on that.
We'll file.
Passing no orders on that.
Malad, these be filing counters in applications, then the main matter, Malad.
There are only two main matters.
There's so many matters there.
No, only one matter in application.
Let's
That's all.
let counter to IA number so and so. Which are those IAs?
We'll give the number.
It's not
We
numbered.
file before the next date of it.
Yes.
Yes, next.
Item 28.
ये
Right.
हमारे notes का इस production है.
G.
22 corrected. 20 is connected.
Huh?
20 is connected.
Yes.
It says something must.
29.
Yes, next.
Well, it's in this matter, this is for anticipatory bail. Now, he has no criminal antecedents whatsoever.
You impersonated this.
That is the allegation on the basis of statement which is made in police custody. Now, between
You have said in one of the ground
yes,
that settlement agreement
that's right, my lords. We
has
can
been entered into family members of other person with the
right.
complainant.
that is on record at page 60. So the money has now been given to the vendee.
Yes.
Page 60.
On the ground of settlement.
Yes. Okay. Ms. Tika Devadi, learned counsel for the petitioner, who submits that the petitioner was not named in the FIR, and as a matter of fact, in matter of fact, which is that page?
Page 60.
No, 60 is something different. Bail application.
No,
Where is that agreement?
page 44. Sorry, I'm so sorry, my lords. The settlement agreement is at page 44.
As a matter of fact, tell me.
Okay. In council का नाम, the lead counsel petitioner would submit that petitioner was named in the FIR, and as a matter of fact.
And as a matter of fact, the complainant and co-accused persons have already entered into a compromise, and the entire amount in question has been refunded to the complainant. Issue notice returnable on 10th February. In the meanwhile, petitioners shall not be arrested in relation to crime number so and so, police station so and so, offences under section so.
Very good.
Yes,
What should pass over? madam?
pass over.
Item 1.
Wait, please look. Lord, at the time of issuance of notice, Lord, your Lordship had directed me to first surrender, Lord, then granted specific liberty to file for suspension. Lord, this is
Yes, Mr. Sharma, this is an offence of 1992.
That's correct, Lord. I understand that situation.
Now, after 1992 means 36 years, he sought to be arrested, needs to be examined. Listener, considering that the offence was committed on 29/8/1992, that is more than about 36 years back. And presently the petitioner is in jail from 18/8/25, after his surrender before the trial court, we are inclined to suspend the sentence and release the petitioner on bail.
Lordship may say in the facts of this case, my lord, because he has not undergone even 1/4 of the sentence.
Therefore, considering the facts and circumstances of this particular case, we are inclined to suspend the sentence and release the petitioner on bail. Accordingly, it is directed that on petitioners furnishing, therefore, it is directed that petitioner shall be released on bail on such terms and conditions as may be imposed by the trial court.
Deeply applied. Very good.
Post the matter, records have been summoned.
No, my lord, not yet.
That record of the trial court be summoned and the matter be posted, the matter be listed on 6th April.
Very deeply applied.
Grateful, my lord.
Yes,
My lords, I passed over item 5.
Need the lordship.
pass over.
Yes, this is that matter where the cost.
I appeal for the
Only about cost.
the notice was issued to the limited aspect.
Yes, yes. Leave granted.
Yes, sir.
Under the impugn order, the High Court has quashed the notice issued by the Additional District Magistrate Hapur in so and so ये अपने order में लिखा हुआ है 28/11/25 के order. There are two matters.
Yes,
Two
no,
matters.
same, exactly the same order has been passed.
ये देखिए दो केस नंबर लिखा है, एक एसएलपी का एक केस नंबर है, एसएलपी का दूसरा केस नंबर
जी।
ये कॉमन ऑर्डर है करके दोनों का एक साथ लिख दिए. अच्छा दोनों का कॉमन ऑर्डर ही बनाओ. कॉमन ऑर्डर so and so in case number so and so full stop. While quashing the notice under challenge before the High Court, comma, a cost of rupees 20,000 has been imposed on the state of UP in each of the case, further reserving liberty in favor of the state to recover the same from the concerned additional district magistrate. Having examined the matter, we do not find that the High Court has recorded any finding that the concerned additional district magistrate has passed the order which was under challenge before the High Court in modified exercise of power or due to any extraneous consideration. In such view of the matter, imposition of cost of rupees 20,000 and directing the same and reserving liberty in favor of the state to recover the same from the additional district magistrate is not justified. Accordingly, we quash the said part of the impugn order imposing cost of rupees 20,000 on the state.
What's the question of law and that would be left open in other matters also because that will
I have already dismissed that part. That part is already covered in our order issuing notice.
Very well.
Yes.
Deeply applied.
My lords, this
Am I
order-
audible? My lords, am I audible?
Yes, yes.
My lords, this is a transfer petition by a wife who is based in Kanpur, and she's seeking a transfer of the Section 13A petition from Gwalior to Kanpur, my lords, which is approximately more than 300 kilometers far. Now, my lords, also see annexure 4 of my petition, my lords.